What do you need to do to introduce a screenshot into evidence? To find out, you have to read People versus Rodriguez, but it's 5 pages. Don't have time for that? I've got you covered. This is TLDR, the case of People versus Rodriguez. This can be found in 2022 New York Slip Opinion 03307, published by the Court of Appeals on May 19th of 22. The issue here is what is required to admit screenshots into evidence, screenshots from the cell phone, digital evidence. To understand this case, you have to understand that there's a lot of different objections that can be lodged when someone is trying to make a motion to admit a document or an exhibit. And the two important and relevant ones that we're going to talk about now are authentication and the best evidence rule. Authentication is basically establishing that a thing, a non-testimonial piece of evidence, so an item in the world, is what it purports to be. So if there's a robbery with a gun and I offer a gun, it has to be not just a gun, but the gun that was used, or the same kind of gun, if that's what I'm trying to establish. You have to establish that there's some connection between the thing and the case under consideration. How do you prove this? It can be by testimony of witnesses. It can be by circumstantial evidence. There are various ways to establish authenticity, but that's what authenticity means. And the second thing you have to understand is the best evidence rule. People often misuse this. It's misnamed. It's not the best. It's not the objection. There's better evidence for this proposition or this fact. That's not what the best evidence rule is. The best evidence rule is a preference for the original. That's how you should think about it. And basically the rule is that if there's a document, that you're trying to admit and the contents are important and it's disputed what the contents are, then there's a preference that the original document be admitted. Unless there's an excuse, unless there's a reason. If there's a reason why the original can't be offered, then a copy could be fine. So let's talk about this particular case. The facts in this case are that the defendant is a 43-year-old volleyball coach who starts texting with his 15-year-old volleyball student. And the conversations in the text messages start becoming sexual in nature. And the 15-year-old shows her boyfriend, who then takes screenshots of the conversations between the defendant, who's the 43-year-old volleyball coach, and the 15-year-old student. He then sends those text messages to himself and the victim's mother. Ultimately, these text messages get to the police. It goes to trial, where the volleyball coach is being prosecuted for disseminating indecent materials to a minor in the first degree and endangering the welfare of a child. And the defendant moves to preclude these screenshots, arguing they're not authenticated and they violate the best evidence rule. And the trial court denied it, said there was adequate foundation. And what happened at the trial court is the victim identified the text messages and said, those are the text messages that he sent me and I sent him. And the boyfriend identified the text messages, the screenshots. And they also offered into evidence, the prosecution, the corroborating phone data information, the documents from the phone company saying certain text messages were sent at this period of time between this phone number and this phone number. And the appellate division reversed the trial court and said this did violate the best evidence rule and or authentication. So it goes to the Court of Appeals, and they say this was a discretionary ruling. Evidence rules often are discretionary in the discretion of the trial court, and therefore it would be governed by an abuse of discretion. So only if the trial court abused discretion or there was no legally sufficient proffer made as to why this evidence is admissible should it be disturbed. But they also say that for digital photographs, they basically say that we're going to treat digital documents, digital photographs, just like non-digital photographs. The witness testified that the screenshots were fair and accurate representations, and that is sufficient authentication. That is sufficient authentication that the photographs are what they purport to be, the photographs of the screenshots. And with regard to the best evidence rule, that was satisfied in terms of it not being the original, it's digital content. So any copy of the digital content is an original for the purposes of this particular Court of Appeals ruling. They say it was sufficient. It did not violate the best evidence rule, and therefore they reverse the appellate division and reinstate what the trial court had done. Too long, didn't read, 5 minutes or less. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.